object to the amendment, especially before the ruling on jurisdiction. In fact, we stopped the application for reference to await the ruling on jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction. Because the court has no, it's in our view that the court has no jurisdiction on these two gentlemen, and we see that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure. Any colleague?
Council, which ruling are you talking about? Which ruling are you talking about?
On the ruling that you referred to Mr. Ukwago having argued on your jurisdiction trial. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
From yourselves, from this court martial.
That was really fast at the first. Not the ruling. From the ruling which was delivered when the same day.
Mr. Chairman, we have been under the impression that there is a ruling on several occasions that was supposed to be delivered. And that ruling relates to matters that were raised the first time the accused persons were charged. That matter, I think, has something to do with jurisdiction. It has something to do with the extraterritoriality of some of the offences and how we got here, and therefore it applies to the charges. So we have all along been under the impression that there is in fact a ruling. I do recall my land friend was there once, actually was I said we are ready to proceed. But the events that have taken place since that time have not made that happen. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, it relates to what my land friend has just prayed about, the amendment of charges. I am looking at the rule that was cited on amendment. And it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributable to clerical error or omission. And he did say that in the charge there have been reference to a serving officer. I haven't seen that reference myself in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. You must have known the name, but just refused to put it there. So I'm not sure that Regulation 66 allows him to do what he's asking, than to join Captain Prince. So I just rise on those two issues. The ruling, then prior to what my country is asking.
Mr. Chairman, for the record, blowing buzz in alcohol, I associate myself with submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to attention through preliminary objections raised by my senior land friend, Counsel Karua. Lukwabo, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving that ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeating this.
Mr. Chair, just for recollection, it may be recalled when Senior Colleague Mother Karua was first hearing raised an application for an adjournment for an hour. And court wasn't ready. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver a ruling regarding matters raised by Mr. Ageesigika. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions to receive the ruling and also the matter of Mr. Egenze. So it is correct, if I recall, that it was at my request that we were granting an adjournment of 15 minutes so that we come back and issue the ruling was in the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm that it is correct that there was a pending ruling regarding what was issued. Thank you, Mr. Chairman.
Council, understand that the declaration is 66. One, but we not proceed to paragraph 2, which states at any time during the one at which there is a judgment, it appears to the court before it closes the its finding that it is desirable in the interest of justice to make any addition or omission. So that is the addition. I'm moving the court to so called addition and adding there because this is during the course of investigations. Additional evidence was brought and the counsel is magic, and also another count is also added. In regard to the ruling, we are also expecting the ruling.
Mr. Chairman, just a brief rejoinder with Rule 66. I had read Sub-Rule 2, but my interpretation of Sub-Rule 2 suggested that it only applies when we are at a stage when the court is closing to deliberate on its findings. We are still at the initial stages of this matter. So I still submit that neither to under this 66. 66(1) doesn't help him. 66(2) certainly destroys his arrest.
Allow me, Mr. Chairman, to add just one thing.
My Lord, they have no locus.
We are relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, Regulation 66, 1 and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court on the agenda.
The court is adjourned for 10 minutes.